I suggest to Your Honor that the evidence that has been presented in this case is overwhelming, that this young woman was clearly and unequivocally suffering from a mental disease or defect, that it was occupying her waking hours, her life, that she considered all of her avenues. She attempted to go to these healthcare providers, using the term loosely, that she went to these people. She had medication after medication after medication. She was obviously acting, I suggest to the court, in a state that was observed by witnesses that, in fact, that she was suffering from mental disease or defect, and then ultimately this horrific incident. So under that Burnett-Silvera case, there's no evidence, I suggest, from the government that would rebut the fact that there is evidence of lack of criminal responsibility. So under Burnett-Silvera and the cases that were cited in that opinion, respectfully, I would suggest that a required finding of not guilty should be entered on the case. I also would argue to the court that I think that under the Burnett-Silvera standard and the evidence that Your Honor has before you, that the matter should be reduced down, if you will, from premeditated malice of forethought, cruelty, and atrocity to second degree. I'm not arguing at this stage Commonwealth versus Gray or any of its progeny as to manslaughter, but I think the court, certainly in its wise exercise of discretion, has the ability and the right to reduce the charge to second-degree murder or enter a required finding.
All right, counsel, thank you. Commonwealth.
In this case, as you're aware, defense plans on presenting experts to testify that the defendant was not criminally responsible, and then the Commonwealth will have a rebuttal case with their own experts. So I think the time and place for the motion would be at the close of all of the evidence and not now.
All right. Well, I had an opportunity to take a look at Burnett-Silvera. So based on that and based on the standard as described that I have to apply at this point, I'm going to deny the defendant's motion.